Hello friends, welcome to Sunil Engineering Academy. I am Bharat. We are looking into the polity series of lectures, and today in this class we are going to see the Article 32 right to constitutional remedies, friends. Actually friends, we are looking into the FRs, that is fundamental rights. For this, fundamental rights are judiciable in the sense fundamental rights are the rights which empowers the democratic people. That is, our country is a democratic country. In the sense, the power lies with the people. How does the power lies with the people? One is by adult franchisee, that is, you have right to vote and choose your ruler. Okay friends, another thing is by having the fundamental rights. If these people has a fundamental basic rights, which can be denied, which cannot be denied by any government, friends. Okay, if they deny any fundamental right, you can go to the court and court issues of writs, friends. Okay, this we can see. We have 5 kinds of writs. We call it writs, friends. Okay, these are habeas corpus, mandamus, prohibition, certiorari, quo warranto. Even though the wordings are difficult, please bear with me. I will tell the meaning of them, friends. Okay, so Article 32 deals with a right to move to the Supreme Court for the enforcement of fundamental rights, including the writs of habeas corpus, mandamus, prohibition, certiorari, and quo warranto. Only see friends, if there is any case, if you want to file any case, you have to go for the maximum, you can go for high court, friends. Okay, or you have to start from district courts. If you don't get justice, then you can go for high court, or if not, you can go for Supreme Court. Only for the violation of fundamental rights, in the first hand, you can go for the Supreme Court and file the case, friends. Okay, only for the fundamental rights. If violation of the fundamental rights, you have option. I am not saying that you have to go only to Supreme Court, but even if in the first attempt itself, you can go to the Supreme Court and file the case in the violation of the fundamental rights. Okay friends, and along with this fundamental rights, you have given with five writs, friends. I mean, the court is given with 5 writs with which we can claim our basic rights, friends. Okay, first one is habeas corpus. What is habeas corpus? Habeas corpus means to have the body that is to be produced before the court, and it can be issued against the state and private individuals, friends. Okay, mandamus. So what is the habeas corpus? See friends, if one of your family, I will give the examples, don't worry. If one of your family members or friends are arrested by the police people, okay, you can go to the court and file the habeas corpus. In the sense, if the police people have arrested your loved being, okay, but you don't know whether they are alive now or where they have kept him. Okay, if even if you go to the police station or any government police jail, you if you didn't find him, then you can go to the court and file the habeas corpus within 24 hours. If that court issues habeas corpus within 24 hours, they have to show that person in the court, friends. Then you can know about the whereabouts of that person, friends. Okay, it means that to have the body that is to be produced before the court within 24 hours, it can be issued against the state and private individuals, friends. Okay, that is the usefulness of this habeas corpus. Mandamus. Mandamus means we order or we command. We order or we command. It can be issued against a public authority or inferior courts for purpose of enforcing legal right only. It cannot be issued against the president or governments, friends. Okay, see, if you need any information or details about the cases, then the higher court will order the lower courts or any public authority to give the information, friends. But it should be bound to enforcing legal right. Okay, to know your legal right. It's a kind of RTA, friends. Okay. Prohibition. Prohibition means to forbid. You know the word, you know the meaning of prohibition. It is issued by the higher courts to the lower courts, friends. Okay, or quasi judicial bodies, that is tribunals, forbidding the latter to continue proceedings there in excess of its jurisdiction. Okay, see friends, in a district court, it has taken up a case which is beyond its jurisdiction, which is beyond its capacity. Okay, then the high court will say that, okay, see district court, it is beyond your ability, so stop this legal proceedings. They will say that simply. That is called prohibition. In simple words, I can explain this, friends. Okay, the same way, certiorari is also to be informed, friends. It is used to squash the order of the lower court or tribunal in excess of jurisdiction. If the same example, friends, if the district court has taken up a case which is beyond its jurisdiction, which is beyond its capacity, and it has gave the judgment also. Okay, after the judgment is given, if the higher court says that to prohibit, or we can say that if the higher court cancels that one, then it is called certiorari. Then this higher court will take up the case of that district court and start the proceedings, friends. In short, both are same. In short, both are prohibition. In short, if we say prohibition and certiorari is same, where the higher court interferes in the lower court's case and say that that case is beyond its jurisdiction. Prohibition happens when the case is going on, friends. It is in the processing. Okay, certiorari happens once there is a judgment is given, friends. After the judgment, if the higher court says, okay, it is beyond its beyond your jurisdiction, and if the higher court take up this case, then it is called certiorari. If the case is going on till there is no any judgment, fruitful judgment has come, if it stops that case proceedings and says that you are not capable, or you are limited with the jurisdiction, and it will say just stop, that is, it is called prohibition, friends. Okay, that is the difference. Quo warranto. Quo warranto is another important writ, which means what is your authority, or in other words, by what authority you are doing this work, friends. Suppose it is in which situation this writ is issued by the court. It is issued to ensure that the person holding a public office is duly qualified to hold the office, friends. Okay, you suppose if there is a medical office, friends. Suppose if there is a medical office and there is a director for that medical office, it's a district medical office. Okay, if that district medical office head, that is director of that office, do some work which is beyond his field, or beyond his beyond his work, friends. I mean beyond his medical field. And if someone files the case, if he is doing some social work other than his medical terms, then through government, then if someone approaches the court, then it will ask him, by what authority you are doing this work. If some person who doesn't have any qualification and he is appointed for any higher post in one of the government services, then also the court can ask him, by what authority do you have the capability, do you have the experience to do this work, by what authority you are holding this public office. are holding this task in this public office, they can question him, and this is called quo warranto, friends. Okay, I have put it in very simple words, friends. Actually the explanation is different, but as of now you have to remember this. Writs, see, writs are the weapons hold by the court, and it can be released upon any government offices and public services, okay, for the to safeguard the rights of the people, friends. So you have to remember this: habeas corpus, mandamus, prohibition, certiorari, and quo warranto, friends. And these are very important, and these meanings are also very important, friends. If you don't understand, go back, rewind this video and listen clearly. The explanation is very clearly given, friends. Okay, in the earlier video actually we have studied fundamental rights. In continuation of that, article 32, that is right to constitutional remedies. This is one of the very important article, friends. This is very important, such that the Dr. B.R. Ambedkar, who drafted the constitution itself, he said that article 32 is the heart and soul of the Indian constitution, because it is the only article which gives a right for the people to approach the court, that is Supreme Court, to enforcement of their basic fundamental rights, friends. So that important it holds, friends. Article 32 you should never forget. Okay, this is very important, and it is a potential bit. Which article it is called? Heart and soul of the Indian constitution, article 32. Because as I have said, if there is a violation of the fundamental rights, you can approach the court, friends. Okay, amendability of fundamental rights. Okay, fundamental rights is the, what we can say, is the basic structure of the Indian constitution, which makes our India as a democratic state, friends. Okay, so but in the meanwhile, in the history, if you study, there are some judgments which decide the very character of the fundamental rights, or very amendability of the fundamental rights. In the sense, amendability in the sense the changes. Does the court or parliament, the parliament is capable of changing these fundamental rights? Okay, see, you have to understand the side, the weightage of the fundamental rights. Only then you can really understand this, friends. Okay, see, there is a person and there is a government, friends. Okay, and there is a government. See, government enforces laws on this person, and he has some basic rights, that is fundamental rights. If he want to safeguard these fundamental rights, he will approach the court, friends. He will approach the court. Court will direct the government, friends, or court will direct the system and advise the system to safeguard this person, friends. So court acts upon the fundamental rights. By quoting these fundamental rights only, they can access the system, friends. So what they have seen is that they try to change these efforts. The government, that is the parliament, try to change these fundamental rights. How far this government, that is the parliament, is successful in changing the fundamental rights is the discussion. Have you understood, friends? I hope you have got. Okay, there are some cases. In Shankari Prasad versus Union of India 1952 and Sajjan Singh versus State of Rajasthan 1965, Supreme Court held that the parliament can amend, or in the sense can change the fundamental rights using the article. See, to change anything in the Indian constitution, there is only one article, that is article 368. By using the article 368 tells how to change the articles in the Indian Constitution. Okay, in these cases the judgment has come like Parliament is capable of changing the fundamental rights by using the Article 368. See, if they can change the fundamental rights, they change for their benefits and they will reduce the rights of the people, friends. Parliament will do that. Okay, again in Golaknanda versus State of Punjab in 1967, Supreme Court held that fundamental rights are not amendable. See, friends, how contradictory here. Earlier they said in 1965 and 1952, what they said that they can change the fundamental, that is they can amend the fundamental rights. In Golaknanda case, what they have said, it is not possible to amend the fundamental rights, friends. Okay, in 24th Amendment Act, efforts are made. What they have done, even then they said in 24th Amendment Act for fundamental rights, this Amendment Act is done in the Parliament. What they have done is fundamental rights are made amendable and amended the Article 13, friends. Okay, they have changed the Article 13. In Kesavananda Bharati versus Kerala State, which is very very important, where the term basic structure of constitution has come up, friends. Okay, what they have said in Kesavananda Bharati case, they said that okay, you can change the fundamental rights, but the very basic structure of the constitution should not change. The basic structure of the constitution should not change, but not, they said that yeah, okay, you can change the fundamental rights for the betterment of the people, but not touching the basic structure of the constitution. In 42nd Amendment 1976, insert the Parliament can amend affairs and judiciary cannot interfere in it. This is very radical, friends. Here you can see in 42nd Amendment, they said that Parliament can change affairs and which cannot be reversible by judiciary. They said that court cannot change or interfere in it. This is very radical, friends. Okay, see, if there is violation of fundamental rights, where does the person will go to the court, friends, and he can ask. If the Parliament changes the affairs, and if there is no judiciary interference, how does the person will get the justice? You have to think. In Minerva Mills case 1980, SC ruled that judicial review is the basic structure of the Constitution. See, earlier the basic structure of Constitution, they have given the terminology basic structure of Constitution, but they didn't explain what is the basic structure of Constitution. In Minerva Mills case, they have said that judicial review is the basic structure of the Constitution. Judicial review, that is the approaching the court, is the basic structure of the Constitution. So, and it cannot be amended. And they also said that, so, and this basic structure of the Indian Constitution is nothing but the judicial review, and this is once and for all, it cannot be changed, and this is final, they have said, and this cannot be changed. Then at last, at present, after seeing all these cases and results, what we can conclude is that at present fundamental rights are amendable, that is we can change, but keeping the basic structure of the Constitution untouched. We have to safeguard the basic structure of Constitution. This basic structure of Constitution is nothing but judicial review, friends. Judicial review, that is here, it is the judicial review, that is approaching the court for the safeguarding the fundamental rights. Okay, friends, I have explained you the amendability of FRs within a small period of time. Actually, in civil services, it takes much more, many hours to explain these cases and the result, friends. I have explained in a very short way and simple way possible. All you have to remember is that in which case what is the result, but don't forget that the last, that is at present what they are thinking is that the finally At present, FRs are amendable, but keeping the basic structure of the Indian Constitution untouched, friends. Okay, this is all about Article 32. What about Article 31? We didn't read that Article 31. Actually, Article 31 is deleted, friends. Okay, actually it got deleted. Why it is got deleted? We will see later. But we have changed that right to property from fundamental rights to the it has made of legal right. Right to property is no more a fundamental right but a legal right, friends. It has moved the Article 31 to Article 300A. Okay, by using the 44th Constitution Amendment Act 1978. After this amendment, it has made a legal right, that is 300A in part 12, friends, of the Constitution. Thus at the present there are only 6 FRs. There is only 6 fundamental rights, friends. Okay, so what are the fundamental rights which is available for Indians and which is not available for aliens? That we will see, friends. If you use just the common sense, then easily you can understand, friends. See here, fundamental rights. We will see first the fundamental rights which is not available for aliens. Aliens in the sense which the it is not the living being which comes from the foreign, which comes from other planets, but the foreigners. Aliens means foreigners, friends. Don't think otherwise. Aliens is just the foreigners, friends. Okay, for foreigners there is a discrimination on the place of birth. Okay, so Article 15, they don't enjoy that discrimination. They are discriminated because of the place of birth. So right to not to discriminate against the grounds of race, caste, religion, sex and place of birth. This right belongs to only Indians within the territory of India, friends. Even if you take birth in Kerala or in Meghalaya, you are treated same. But you are taken birth in Bangladesh, obviously will be treated differently. Okay, within the territory of India, yes, all Indians are equal. Right to equality of opportunity in public employment. You can see that in any public application while filling, there is an option called citizenship, and there we will be giving that Indian. Obviously the foreigner, I think he can't apply for that post, friends. Okay, so this is not available. Opportunity, equal opportunity in public employment is not available for foreigners, friends. Okay, right to 6 fundamental freedoms. Fundamental freedoms, you know that right to speech, right to expression, right to assembly, peaceful assembly, right to association, to have an association organization, right to move freely in the territory within the territory of India, right for settlement. Okay, right to operate from that place, friends. All these 6 fundamental freedoms is not applicable for aliens, friends. Okay, right to suffrage, this is for voting, friends. Okay, cultural and educational rights. Okay, we safeguard our own culture and our own educational rights, and this is nothing to do with the foreigners, friends. Okay, some of the offices are can only be holded by Indians, friends. That is office of president, office of vice president, governor of states, judges of Supreme Court, High Court, Attorney General of India and COG, friends. Okay, these are only for Indians, friends. Right to contest in the elections and get elected to either house of the central and state level. Of course, there are some NRI seats, and that is different in Rajya Sabha. We will see that, but to be contest and to be elected, it is only for the Indians, friends. Okay, the persons who hold Indian citizenship, and these does not applicable for the foreigners. Then what are the fundamental rights available to any person in the world or from the other person from the space? If you see, then it is equality before law and equal protection of laws. Article 14, it is the equality before law, that is law is superior and all the other people are below that law only. That is equality before law. I have explained that. Equal protection of laws, that is If there are two people, thus two people will be given equal justice if their situation are also similar, or similar people are judged similarly. If they are if the situation is different for different, then the judgment will also be different. That is equal protection of laws, friends. Okay, protection in respect of conviction of offenses, article 20. Even foreigners are given the protection against the offenses. Protection of life and personal liberty. This is the protection for life and personal liberty. This is nothing to do with the citizenship. Prohibition of human trafficking and forced labor. Even if you are a foreigner, you are not supposed to be a human trafficked, or you cannot made to work as a child labor. Freedom of religion. Yes, freedom as to payment of taxes and promotion.